All right, so welcome back in today. We're going to be diving into not only crypto exchanges, but also a lot of the happenings in the industry around Voyager, Celsius, many of the topics that, of course, are making frontline headlines. I think you guys got to like this one. We're going to break this down a little bit deeper for you. My name is Paul Barron. Welcome back into TechPath. Let's get into it today. I wanted to bring in John Deaton. John Deaton, you, of course, know him through XRP and Ripple fame and the class action case for all the XRP holders. So, John, welcome back into the show.
Thanks, Paul. Appreciate it.
Yeah. John, I want to get into the scenario around these crypto exchanges, along with many companies that have ran into some dire situations here of late. We'll look to Voyager first. And one of the key things, you being a seasoned class action attorney, filing in the crypto sector, when you look at class action cases and the scenario that, as we know, Voyager filing for bankruptcy this morning, we got the news, where does that put people who are out there with Voyager today? Is there a potential here for class action? Do you see, what I guess legal course do you see playing out in the markets here in the coming months, maybe over the next year?
Well, this is going to be litigation for years. That's the first thing. Now, understand too, the bankruptcy filing changes the landscape. There are class actions right now pending against Coinbase and Nexo and Binance, for various types of claims. But when a company files bankruptcy, there is a provision of the bankruptcy law that protects that company, basically stays any lawsuits, right? So if there was any pending litigation against Voyager, it's automatically stayed by the federal bankruptcy statute. And the court would consider those claims along with all the other creditor claims, right? And
Yeah.
obviously, if you're a tort litigant, meaning that you filed a case, civil case, you're going to go to the back of the line in the bankruptcy court. So now a lot, class actions also with these other companies that have not filed bankruptcy, that's a different animal because they're not protected by the bankruptcy laws that would stay the litigation. And so the biggest issue right now with these cases is, Celsius and others, and I'm sure Voyager as well, have, basically waivers of class action lawsuits. They have what's called binding individual arbitration clauses, where when you sign up, you check a box that basically says that if there's a dispute between you and that company, you waive your right to file a class action. You waive your right to file any individual lawsuit, and you agree to an individual arbitration against that company.
Yeah, this is the notice right here from Voyager, just so you guys kind of understand. We reported a little bit on this yesterday, but back to John's point right there, very specific under arbitration clause and class action waiver, which waives your right to sue in court or seek a jury trial for disputes relating to the use of her services. Now, my question is this: when you have we'll stay with Voyager for now. When you have the scenario of this claim of FDIC insurance, and though there was verbiage deep within their statements, a lot of the EULAs that talk about this, and there is a lot of gray area, and I've had a couple of attorneys look at this and trying to understand really where it is. But the fact that we actually had Metropolitan Bank, which is the company, the bank, that essentially supports Voyager, they actually had to come out and do a statement. And this was the day we published a video. It was like the day after we published a video about this very issue. They're actually clarifying the position that Metropolitan Bank is saying, hey, wait a minute, if you're a Voyager customer, it doesn't mean you have FDIC insurance with us. So with that kind of scenario, this could be construed as clear miscommunication at the very least, to where it could confuse consumers and investors, obviously, that are in the Voyager. What happens when it is getting into those waters? Because now you're outside of just the point of a failure scenario. You're actually looking at confusing advertising, confusing terms, all those kind of things. I won't say the word, but what happens when those kind of things come up in this type of case?
No, great point, Paul. In order for a contract to be valid and the terms of that contract to be valid, both sides have to be on the same page, right? There has to be what's called a meeting of the minds. So if one side, let's take Voyager, if they are misrepresenting things, then that person relied on that misrepresentation, right? They didn't get true, accurate information to make a voluntary decision. So a
Mhm.
waiver of a class action really comes down to, was the customer voluntarily and intelligently and knowingly waiving their right to a lawsuit and a class action? And if they were, then it's a valid provision. But if there is any allegation of fraud, misrepresentation, or omission of material information, then you can basically argue that that provision of the contract is invalid because of those misrepresentations. And then, if you're successful, there would be a motion to dismiss the case, for example, based on that provision, that you go to arbitration and you can't sue, and then the person, the customer, your lawyer would challenge it and then show the judge the misrepresentation, and then there would be a decision. And if the judge agreed with you, then you could proceed with the class action or the litigation. If the judge disagreed with you and enforced the provision, you wouldn't be able to sue. So that's your point is excellent, because uh, I wouldn't say it's confusing, and that's the standard. So what you articulated is correct. Confusing advertising, you're confusing the customer. It's up in the air. But if you can prove misrepresentation, then
Mhm.
that's the home run to overcome that provision. Because then you're
How do,
basically saying, look, you can't enforce this contract, judge, because they were fraudulent. They
yeah.
misrepresented. I would have never entered into this contract and gave up those rights if I knew that this information wasn't accurate. So,
So, okay, so your scenario here, this was from a tweet that just came up, and they were tweeting at us, and it was really kind of the issue of your USD is FDIC insured. This is something that comes up in the Voyager app. It's often stated on the website, all those kind of things. For a lot of people who had US dollars in the Voyager app itself or within the Voyager platform, and I guess this would be the real question is, how does that apply to a bankruptcy hearing? And I kind of think of this as a bank. If you look at it from a bank's position, the Federal Deposit Insurance Corporation comes in, they repair all the depositors. In the case of a potential failure, banks maybe in some cases, I guess, could go either insolvent or bankrupt or file bankruptcy. But does that change the landscape at all for those who had US dollars in there that were alluding to FDIC insurance?
yeah,
Or
I
would they still
actually,
fall under the bankruptcy proceedings?
well, I think, Paul, now that you showed me that, I was a little curious. Celsius hasn't filed bankruptcy, right? And
Right.
and Voyager, in my eyes, Voyager was pretty quick to filing for bankruptcy protection, and I think they may have been advised by their lawyers. I don't know how solvent or insolvent they are, but the lawyers may have looked at that and said, "Listen, you need to be protected from these class actions, from this litigation, because they could overcome those anti-waiver provisions because of this
Mm.
fraud or this misrepresentation, this confusion." And so it may have been a decision, but the reality is it's very, unfortunate, but the law is clear. They're protected. Any litigation, if I were to file a class action lawsuit right now against Voyager, immediately I would receive a notice that it cannot move forward and I'm in violation of the law because they're protected by bankruptcy protection.
Hmm.
So the question then becomes, can you pierce, like the
Yeah.
corporate entity, can you pierce it and show fraud behind individuals, right, who are promoting it? And so that's going to be another form of attack.
Yeah.
And I don't know the Voyager story. I don't know who the owners were or the promoters or the corporate structure. But that's why I said right now it's protected, but this litigation is going to play out for several years.
So within a federal case, if it does, I mean, we're not giving legal advice here in any way. What we're trying to do is discuss kind of the options and scenarios that most likely, if you guys are out there and you've invested in one of these companies, maybe you're at risk. Obviously, you should seek your own attorney, get with them, understand where the markets are and your own situation. But I look at it this way, and I've been in cases where our business was a creditor and a creditor to companies who failed. In many cases throughout my years, I've lost many scenarios where we never got made whole because they either filed bankruptcy. But there was one case where we did run into a scenario where we were a creditor, and the person who we were a creditor to, there was fraud in that case. And we along with other people within the case were able to pierce the corporate veil and be able to get to civil lawsuits within that kind of scenario. Does fraud, is it one of the bigger scenarios that plays out in something like this that kind of pierces the potential for a federal bankruptcy protection?
Absolutely. And I'm really, if there was that kind of misrepresentation by Voyager, where they're really basically soliciting business by giving them a false sense of protection, you know what I mean, as an FDIC insurance, by definition, that meets a prima facie case of fraud. And so that's why I also think that they may have been rushed, which is, listen, if we don't file and get protection from the court that would stay all litigation, we're going to get hit with a slew of these class action lawsuits or individual lawsuits. And so, I think, but you're right. As in your personal experience, it was the fraud that was allowed you and the others in the group to pierce what's called the corporate veil, and then you can attack the person who's behind it if there's assets. To give people an example, if you had a Brian Armstrong, if he committed fraud, right, and Coinbase filed for bankruptcy, but you could prove fraud, you could then go after him individually. And I'm not suggesting that he's done anything.
Sure, I'm just understand.
Just giving an example.
For sure. All right, so crypto exchanges in general right now, heavily under fire. We're seeing a lot of changes within these terms of service, which they have the full right to do. We're seeing a lot of changes that are kind of happening on the fly, especially around withdrawal limits. And one thing that has happened with many companies is they've either slowed withdrawals so that we don't end up on these bank run kind of scenarios where liquidation and also liquidity becomes a big issue. The protection of a lot of these depositors, much like with a bank, there's really nothing there that's going to control a current or an exchange of being able to go in and change their terms of service, which they can do at any time. But down the road, do you think we're going to see more regulation on these exchanges to get more transparent, I guess, with how customers' money and assets are being controlled in the future? Because obviously we know that happened with Celsius, of how they were leveraging up in DeFi. What are your thoughts on where regulation is going to go around this overall?
Well, a lot of people think that I'm anti-regulation because I'm fighting the SEC, so hard. I'm not. I'm in smart regulation, and the industry, Paul, to move forward, they've got to become more transparent. And so there has to be sensible regulation that and disclosures where there has to be, in my opinion, at a minimum, even if it's a private company, they're not public, where they have to disclose, at least every quarterly, preferably it would be every month, where you would see their assets, liabilities, where the money is, whether or not they're engaging in these high leverage strategies, because let's face it, in the bull market and everything's going up, these strategies pay out.
Sure.
Right.
Yeah. Nobody's worried about it at that time. Yeah.
Nobody's worried about it. But I'd also say that, listen, let's all be honest for a minute as well. If someone says, I'm going to pay you 20%, return on your Bitcoin or your XRP or whatever token it is, if it sounds too good to be true, it might not be true, or it might be so leveraged that it's at risk. And
Yeah.
you have to disclose the risk. Speculation's okay, and speculation is what the market's built on. But there has to be, the consumer has to appreciate, that risk. Am I risking my underlying capital to get that 20%? And if the
Yeah.
market becomes illiquid, is that truly at risk? If I voluntarily know all that and I still engage, fine. But
Yeah,
what's
exactly.
happening, that's not happening. So I agree. Unfortunately, too, is that the Celsius, the Voyager, all of the things that you and I are talking about, it's giving Gary Gensler a lot of ammunition to say, look, we got to have regulation, except he wants to over-regulate us, right? He wants to come in and say everything other than Bitcoin's a security and needs to be registered. And so we have to be careful. But if the industry is going to move forward, they have to become more transparent, and we have to get some kind of sensible, smart regulation that requires these disclosures. Our exchanges, what are they doing? Are they making trades that are, against the consumer? Like, just be open and honest about it.
Yeah. Well, there's a lot, obviously with these that would start to put a lot more pressure into your exact point, and that is whether it's the SEC or just regulators in general, where we do see a stiff arm or a heavy arm, much like what we saw with MiCA in the EU. I mean, that particular proposal and what's happened now with the EU is there's a lot more pressure on stablecoins. There's a lot more regulatory guidance on exchanges, and including around this whole scenario around securities in these exchanges. So I see all of this getting into a very interesting time right now in crypto. When you think back around 2017, there just wasn't this many companies that were really excelling like what we saw in this last run in 2020-21. But now we're seeing kind of the fallout. So everybody's learning from all these mistakes. We're seeing all sorts of restructuring, most likely. The landscape of what our exchanges will look like in 3 or 4 years is probably going to be quite different than what we see today, all because of what essentially has been happening over the past 6 months. So a lot of crazy stuff out there in the marketplace right now. John, I know that you guys are all over this. I'd love to kind of pick your brain as things continue to develop, because I think there's a lot more coming down the pipe for sure. But I want to thank you so much for stopping in today. We appreciate it.
Thank you, Paul. Enjoy it as always. Talk to you soon.
All right. Take care. All right. So you guys are
Bye-bye.
tuned in over on the podcast side of things. Make sure and jump over here to the YouTube channel. This is the place where you're going to catch all these exclusive interviews, and really where we dive in deep on a lot of insights around the crypto, blockchain technology, kind of the evolution. But the one thing I can say right now, guys, is not your keys, not your coin. Get onto self-custody. With all of the turmoil we're seeing, you need to get into a self-custody strategy for what you're doing out there in crypto. If you guys want to reach me, it's out there on Twitter, @Paul Barron. We'll catch you next time right here on TechPath.